Welcome back to CVine International News Network. I'm Linda Forsyth.
And I'm Leonard Bacani.
And we are here today where we're just going to jump right into discussing these transcripts for the March 2019 military tribunals for KSM et al. So I'm going to start at the top of the actual article. Today we're having a discussion about the transcripts for the KSM et al. Pretrial military tribunals for the month of March 2019. This is a study page. Therefore, our written report and video is not produced with tabloid-style embellishments or sensationalism meant for entertainment. It's not for those purposes. Everything provided here is backed up with source for the public to fact check. Now, next part in this actual article, so these here are actual transcripts directly from the Department of Defense website for the month of March 2019 and provided here for your convenience. Take the time to download, print out, or review in the PDF format. So what we did is we copied and pasted those actual links from the Department of Defense, and it's right there. If you will please go to c-fine.com, our website, c-fine.com website, and we will have an actual link to this article located here on YouTube that'll take you directly to it. Also, if you wanted to look at other things that it's in the about what we've done for the military tribunals, we have a military tribunal tab that is located up top in the taskbar. Take a look around there. I think there's a lot of information you may find interesting. And last but not least, I am going to mention that since we are the ones that are covering all our own expenses when we go to these tribunals and take time off work and do what we do, we really need help in helping to fund these. And the next tribunals are in the end of April, which is less than a month. So if you would be kind enough to donate what you feel is worth this, we would deeply appreciate it. Okay, so as a reminder, and when you go ahead and download these transcripts that were released by the DoD, we wanted to tell the new people that are coming on here that there's something on the transcripts that says unofficial and unauthenticated on them. Now, CVine News specifically asked Ronald E. Fleisvig about this, and Ron is the public affairs specialist in the Office of Military Commissions, and he stated that these transcripts are released as is to be used as reference material, but may have misspelled names or incorrect punctuation. But the content is accurate and was vetted for release to the public by the DoD. Also, for those of you who are new and do not understand who is really at Gitmo right now, at the bottom of this report, if you go all the way down to the bottom, we have every single name and individual, bio, and the charges brought against them for why they are in Gitmo. So we have that there for you. There isn't any reason for you to ask who's at Gitmo. Go there to the website. It's all there for you to read. Okay. So, Leonard Bacani traveled to Washington, D.C. for the CVine News on assignment to physically watch and prepare a report for this round of tribunals. The tribunals were live streamed via CCTV to Fort Meade Military Base coming from Guantanamo Bay, Cuba, with the same 40-second delay as Gitmo. He watched the first day of proceedings, and then on the next day, the proceedings were conducted in closed hearings in which no one could observe. So then Leonard took this opportunity to conduct a live report in front of the White House, and I was so proud of him. He did a really good job. It was his very first live report, and I think he did a great job. So he wanted to give a briefing of some very explosive findings from that first day of the tribunals. And so this briefing could only be published after the transcripts were released from the DoD, even though we did it live. It is there now on tape. So right here in this article is a click to that link of where Leonard gives a little bit of a hint about what's coming up. So you want to take a look at that. It's right there. All right, getting back to it. Follow along with your transcripts or listen and take notes. On March 25th, 2019, the RMC 803 session was called to order by Military Judge Colonel Perella at 900 hours on Wednesday, March 25th. Judge Perella announced that they would take up 8 motions filed by lead defense counsel for accused Al Belushi. 6 of the motions would be public and 2 of the motions would be in closed session. Now on page 95 and 96, Mr. Connell, the lead defense counsel for Al Belushi, had said, "Your Honor, at trial, the government seeks to introduce telephone calls involving Khalid Sheikh Mohammed and 3 other defendants made before and shortly after events of September 11th, 2001. At the same time, the government seeks to avoid the obvious questions. How do they have those telephone calls? And when did they acquire them?"
Let me make an observation here. It's obvious that the government didn't want to reveal sources and methods, in other words, national security secrets. The defense was under a gag order, which is a court protective order prohibiting the mentioning or even discussing sources and methods in open court. The court has a delicate balancing act in that he has an obligation to provide the accused a fair trial, but at the same time, he has to consider national security concerns.
Okay, thank you, Leonard. Now, on page 110, Mr. Connell said, and that is the correct way to pronounce it, the government acknowledges this essentially in its parts of its brief. Its description in AE 575, paragraph 2E, makes clear that the government seeks, quote, a substituted evidentiary foundation to be read into the record by 2 different FBI witnesses in open court. Clearly testimonial. Now on page 111, you want to take a look, it states, "I am prohibited by the gag order." I think this is Mr. Connell.
Mr. Connell.
Okay. By the gag order, protective order number 3, from arguing the specifics of sources and methods, although I easily could based on open source material as well as unclassified discovery. That prohibition itself violates my personal First Amendment rights as well as Mr. Al Belushi's due process rights. Take also a look at page 112. Mr. Connell claims Mr. Al Belushi had relatively minor participation. On pages 113 to 114, Mr. Connell said, the government claims in AE 601B that this is an unclassified paragraph. The 118 telephone calls are associated with 5 telephone numbers that are otherwise significant to the FBI investigation regarding the 9/11 attacks. Cross-examination would reveal the nature of that connection as well as when to how the FBI acquired these 118 calls. This is before 9/11, folks. Okay, so in other words, as is stated in the actual report that Leonard did in front of the White House, the government knew about 9/11 before 9/11 happened because of listening to these phone calls that they have. And if you continue on, let me see if it mentions it here.
In other words, the calls could reveal who else may be involved other than the 5 accused. And then what you want to think is, think the domino effect.
Right, and it does mention that here. The government claims in AE 601B on page 3 that from those 118 telephone calls, the prosecution identified it as a subset, the translated and or audio content of which it intends to use affirmatively. Cross-examination would reveal how the government selected the records it chose for the exhibit, and the witness could describe the content of the other calls. So in other words, as Leonard just said, the calls could reveal who else may be involved other than the 5 accused. Now, also, one thing it does not mention here, but is in the actual transcriptions, there was a total of 25 lines that were different lines that were found within these 118 calls that they actually taped. And of those 25 phone lines, there were 5 individuals that were positively identified through the person that did the...
A linguist.
A linguist. Yes, thank you. So, as Leonard said, think domino effect. Mr. Connell challenged the chain of custody. Questions about those 2 statements would address the chain of custody and the admissibility of the exhibit itself. Okay, please move on to page 114 and 115. And 4, An FBI linguist made positive voice identification as to 4 of the 5 of the accused United States versus Muhammad et al. Based on this review. If examining a witness, cross-examination would reveal where did these quotes, known voice samples, come from. If they came from the CIA and a black site, it would support our claim about FBI involvement in the RDI program and the connection between the FBI and the CIA.
The black site is a CIA detention site where terrorists are taken for enhanced interrogation techniques.
Torture. Okay, Mr. Cannell said it would also provide a basis for suppression because 10 U.S.C. 948R prohibits all evidence, which it is not limited to testimonial evidence, all evidence which was obtained by torture. If these were CIA voice samples, we would have a very strong claim that they were acquired by torture. Mr. Cannell is suggesting evidence against Mr. Bellucci should be thrown out for the basis of fruit of the poisonous tree legal doctrine because evidence was obtained illegally. Fruit of the poisonous tree is a legal metaphor in the United States used to describe evidence that is obtained illegally. The logic of the testimony is that if the source, the tree of the evidence or evidence itself, is tainted, then anything gained, the fruit from it, is tainted as well. So if the judge rules that the enhanced interrogations or torture is illegal, then all the evidence statements are to be excluded and cannot be used against Mr. Bellucci or any of the other accused. That's pretty significant.
Gets thrown out.
Yeah. Mr. Cannell, wants to cross-examine the linguist who identified the accused by voice to determine the qualifications and expertise of linguists and to determine who had access to the intercepts and reports. Going on to page 116, please observe. Cross-examination would explore the basis for their knowledge, the specifics of the aliases they believe to be used, the specifics of the coded statements that they believe to be used, and would explore the fascinating statement that the FBI further determined that the code telephone calls contained code statements, not an individual, but an institution, and exactly who was involved in that. Now, pages 123 to 124. Now that the first fact that we rely on in 601B Gov is that of the United States acquired telephone calls between April and October 2001 that were later determined to pertain to the planned attacks on September 11, 2001. How we acquired those phone calls is something that's a protected source and method that we've sought to protect within this litigation, and specifically ask for the substituted evidentiary foundation. So the CIA basically intercepted the terrorist phone calls between April and October of 2001. The CIA had the information prior to the terrorist attack that happened on September 11th, 2001. That's a biggie, folks. The government claims that the intercepts are not testimonial and therefore not subject to cross-examination. Mr. Cannell said, now, in response, the government claims that the exhibit itself is not testimonial. The government says nothing about the hearsay foundation statement, the 7 statements we just reviewed, which are clearly testimonial. The government does not claim otherwise. The exhibit itself is not a business record. It is not a phone bill. It is not a call data report common in criminal cases. Rather, it is a curated exhibit created by the prosecution, as they clearly admit on page 3 of their brief AE 601B. The exhibit itself is not a business record. It is not a phone bill. It is not a call data report common in criminal cases. Rather, it is a curated exhibit created by the prosecution, as they clearly admit on page 3 of their brief in AE 601B. Now, the Military Trial Counsel prosecuting attorney, Mr. Trivette, said 4 of the 5 accused were identified by the linguist by comparing audio recording of the accused and then comparing them with known voice samples of the accused. 3 of the 5 accused self-identified themselves during the phone calls. Mr. Trivett said the defense was free to cross-examine the prosecution's witness, specifically an FBI intelligence analyst, FBI linguist, and a Belushi linguist. Mr. Trivett said the protective order is simply a prohibition of defense in inquiring as to how the U.S. government was able to acquire these telephone calls. Understanding, this is a quote, that there will be certain times when classified information is not relevant to the proceedings. In order to protect it, it permits the military judge to exercise certain information, which we ask and was approved by Judge Pohl in our ex parte filing to do. Mr. Trivett argued, so while the accused does enjoy the right to cross-examine the witness who testify against him under 10 U.S.C. 949A, it's clear within the Military Commissions Act itself that Congress never intended full Sixth Amendment confrontation rights as they are enjoyed in the federal district court. So, the only thing that is potentially hearsay that would not otherwise be admissible is the substituted evidentiary foundation that is specifically authorized by Congress in the statute. Like I said before, we're not apologizing for any of it. They weighed and made a determination that when prosecuting enemies of the United States, where there is a strong evidence of their involvement in war crimes, that we should be able to use that evidence and still protect the national security implications of whatever source and method by which we obtained it. We're not doing this very often. The RMC 803 session recessed at 14:53 hours on March 25th, and then it was called back to order at 15:19.
I'd like to interject something here. That's why we have things, the terrorists being tried at the military tribunals, and we're going to have others tried in the military tribunals as well. As you can see, it's going to be different. The rules are different slightly for military tribunal court versus civilian court, in that it's actually more lax. In other words, it gives more power to the prosecution.
Okay, that's good to know. Mr. Connell argued, excuse me, the Military Commission should revoke Protective Order Number 3. Protective Order Number 3 interferes with Mr. Al-Belushi's right to present a defense in two ways. First, it robs the information and telephone calls of all the aspects valuable to Mr. Al-Belushi's defense, while leaving the one remaining argument that the government wishes to make, linking the co-conspirators. Okay, second, it prohibits Mr. Al-Belushi and his attorneys separately from asking questions or making arguments in court which would develop the factual basis that the members need to make an informed decision, or that Mr. Al-Belushi needs to oppose the government protective order in the first place. I respectfully request the Military Commission to rescind Protective Order Number 3. If the Military Commission will not rescind Protective Order, not rescind its Protective Order Number 3, but temporarily suspend it, and then allow me to re-argue the inadequacy of allow me to make this argument again without the restrictions of Protective Order Number 3, which would at least emulate an adversarial process over Protective Order Number 3. Thank you. Mr. Al-Belushi, in setting a date not later than, the date in which the armed conflict between the United States and Al-Qaeda began, which, again, Mr. Al-Belushi believes happens after September 11th, 2001. Mr. Trivett argued that the war on terrorism started prior to September 11th, 2001. The prosecution theory of hostilities the prosecution theory of hostilities in this. In 1996, Osama bin Laden declared war on the United States. In 1998, he made clear that the American civilians, no matter where they could be found around the world, were legitimate targets of his fatwa and declaration. Al-Qaeda attacked the United States embassies in Kenya and Tanzania, killing 257 people. They attacked the United States warship USS Cole in Aden Harbor in October of 2000, killing 17 and wounding 39. And they attacked the United States by hijacking 4 planes, flying them into 3 targets, and killing 2,976 people. After the embassy bombings, 2 weeks later, the United States fired over 80 Tomahawk missiles at Osama bin Laden-related facilities in Sudan and in Afghanistan. At trial, that's either going to be enough or it's not. It's either going to be sufficient or it isn't. It was sufficient in Hamdan. It was sufficient in Balu, and we believe it will be sufficient here. And while our position is that the armed conflict started as early as 1996 and no later than August of 1998, for this cause, that doesn't matter. All that matters is whether or not September 11th attacks were sufficient, which we believe they are. So while we'll prove all of it, we need to prove is that the September 11th attacks happened and that the Al-Qaeda was responsible for it and that it was sufficient to establish armed conflict. Now, on 3/26, the next day in 2019, the sessions were conducted in a closed hearing. You want to explain why?
Well, obviously, like the judge explained in the very beginning, they said 8 total motions were going to be heard, 6 were going to be public, and 2 were going to be held in closed session. And they were going to discuss the 2 motions that were just going to be held in closed session.
Okay, so excellent. And that was one of the things that was mentioned on Leonard's White House report that he did. And so if you haven't listened to that, you may want to go back, and it gives you a little bit more background about this. And he did that on the day that it was closed. So on the next day after that, which was on a Wednesday, 3/27/2019, the RMC 803 session was called to order. Military Judge Colonel Perella at 0900 on that Wednesday. All attorneys for government were present in yesterday's hearing, were present today. Judge Perella noted the following accused have been absent: Mr. Mohammed, Mr. Banal Shabi, Mr. Al-Hawasi, and the remaining accused are present.
You know, I just wanted to interject here. Mr. Mohammed, he's the supposed mastermind. He had an issue with female escorts, and in protest, he refused to attend the court hearing. He wrote to the judge, "I knew I have to be present during the first session, but the rest of it not compulsory to attend, and if the government insists to bring female escorts, looks like given to me in each first session, then it is my decision to accept or refuse the other session." In other words, he was protesting the fact that he's being escorted by a female, and he didn't want to go to court if the government was going to continue providing female escorts.
Oh, well. Mr. Muhammad had an issue with having a female escort, which is what you were just talking about. Right. And in protest, he refused to attend. He wrote, "I knew I have to be present at first session," so I'm not going to repeat that. Leonard just said it very well. Judge Perella said during that 802 conference, Mr. Cannell asked the commission to consider taking up the issue of whether the commission's ruling in 502 BVBB with respect to the existence of personal jurisdiction should be applied to the other accused who were not the proponents of the initial motion that led to that ruling. The government indicated that they were prepared to argue this should the commission deem it appropriate, although they didn't believe that oral argument was necessary. After taking it under advisement, the commission decided to take this issue up in open session and as such issued an amended docket order. What's at issue is the prosecution for the U.S. government makes its case that the armed conflict with Al-Qaeda and other Islamic groups, aka the war on terrorism, started much earlier than September 11th, 2001. It actually started from when Osama bin Laden declared a fatwa in 1996 and declaring war on the people of the United States and our government. So in opposition, the defense attorney argues for al-Baluchi, stating that when he was caught on tape between April and October of 2001, the United States was not yet at war because 2011 hadn't happened yet, and therefore can be tried in a federal court away from the other 4 accused terrorists. So the benefits of a federal court versus military tribunal are more attractive to the defense because of the lax
Right.
I should say lax, not as stringent as military tribunals.
Right. Exactly.
So that is, for the most part, the end of this report. To encapsulate very briefly, the overall, even though we did not go over the entire transcripts, these that are stated here in this report are the ones that you should take special note of and study to understand completely what's coming out of them. So there's been a couple of things of interest that came out of these that that you are going to want to take note of. Now, one thing I wanted to bring up, these proceedings in March initially were supposed to start on March 18th and then end on March 25th, the end of March, on that Friday. And they went in later to go ahead and pretty much chop the whole thing in half. And so that was when they amended the calendar, and it started then on March 25th. So that left 5 days versus the original 10. And remember back from the January proceedings where the judge had a medical emergency of a detached retina, and he had ordered Belushi to be tried in a closed hearing with a translator, and wanted that under closed hearing, even though the defense team argued that he was not meeting that high bar that was absolutely necessary in order to close a proceeding. These are rules that have changed, and they do have to meet this high bar. Well, after he went ahead and ruled it was going to be in a closed hearing anyway, he had the detached retina. So the remaining 3 tribunals, 3 days of January's tribunals, were then canceled and put forward to this March. So they lost 3 days from those pretrial. Then they knocked off a week in March, which was supposed to have started on March 18th and started on March 25th. So they had 1 full day of proceedings. The second day was closed proceedings that was discussing the explosive information that came out about the government knowing about 9/11 before it happened. And so that was in closed proceedings. And then the third day, it went on for half a day. Now, one thing I am going to bring up as a point, because I have read through all of these. Originally, on that Friday, a couple of days later, they were supposed to be discussing the findings that were held in the closed proceedings for Al Belushi, who had the translator there. So in other words, they were going to talk about exactly what came out. Now remember, Al Belushi is the money man. He's the one that funded a lot of these. And if they got him on tape, talking to various different people, chances are pretty good, and this is under assumption, that they probably could identify a few of the other people. Would you say?
One thing I would like to note, though, Linda is a nurse by background, and she made an observation that the judge had a detached retina. And you know what? Why don't you tell me what you told me when that happened?
Well, they had stated, actually this was reported from the Miami Herald, where I read this, that they found the information that the judge had a detached retina, the journalist there did, by talking to the wife, and that they airlifted the judge off of Gitmo to stateside for emergency surgery. And I thought it was kind of strange, considering a detached retina and that change in pressure. The last thing that they would do is put you on a flight in that type of situation. I mean, a complete blindness could happen, a complete detachment, any number of different things. They wouldn't have done that. So that's just my personal observation, but we'll see. We'll see. Okay, now down at the bottom, as I mentioned before, are all the links. Some more information. Please go ahead and read through these, because it seems like every single video we do, somebody doesn't take the time to look at this and understand who is at Gitmo, what they are there for, what their names are, what their bios are, what their accusations are, and then plus the people above and beyond KSM et al. Are other terrorists. There's a total of 40 people at Gitmo. We have them all named. We have all the situations in there. So no excuses. They're asking these questions because everyone's just going to know you didn't read it. So, all right. We are going to be having the rest of this week, I'm going to be calling some defense team attorneys for the accused. And I am going to be videotaping some of this discussion we're going to have. I found out through Ron Fleisberg that this was something that journalists do quite often. And so let's hear what the defense team has to say, because they can apparently come out and say quite a bit. Also, Leonard met a gentleman there at the tribunals.
Right.
I don't know if he was sitting right next to him, but why don't you tell him who he was?
Well, he was a law professor for Indiana University, and he actually specializes in this military tribunal coverage. And so he's interesting. We might reach out to him and talk to him as well. But on the first, I sat next to actually one of defense counsel's father, James Cottrell II. So he's junior, so that was interesting.
Well, and plus some other people that were given to us. We're going to be doing some interviews to get some more technical background, and we're going to bring that to you to be able to talk about it. But for right now, you're just going to have to take the time to go over the actual transcripts and become familiar with it. So when we bring people to discuss this, you won't be lost. You'll have a pretty good understanding about what is happening. Okay, well, I'm going to go ahead and wrap this up. We are going to be posting all of these links on the YouTube, so that will be there. And if you would like to discuss all these discussions and just get into a debate with other people that have studied this, there are multiple places you can do that. There, of course, is the c-find.com website. We have an actual forum there. It's an international forum. There are forums in there from all different countries. Go ahead and register for that. And then, of course, the Facebook page on which is the C-Vine International News Network group page. We have quite a few people discussing things in there. And the request of, again, go to the donation section on our cvine.com website, and please consider contributing to help us cover our expenses. All right. Good night, everybody.
Good night.